So, guys, this lawyer has come out to vindicate Nnamdi Kanu, saying that it was the military invasion into his house that led to him fleeing Nigeria. That if the federal government had allowed him to stay peacefully in Nigeria and then try him during that period, that wouldn't have gotten to this level where we are today. So he now made reference to what the federal government did that led to what is happening. He also talked about the marginalization, that indeed the country is not balanced for everybody and that the federal government has to pay real attention to all that. That Nnamdi Kanu is not just making empty agitation, that there is really a cause, there is a reason behind the agitation, and that the federal government should address that agitation and also take Nnamdi Kanu's case, seriously to make sure that this matter is resolved. This is coming at a time when the coalition of northern groups has issued a very serious warning. See what they said. They said, Peter Obi, other Igbo leaders pleading for Nnamdi Kanu's unconditional release must be held as terrorists. Coalition of northern elders. They are saying that those who are asking that Nnamdi Kanu should be released should equally be seen as terrorists. Nigerians, what kind of audacity do these people have to talk to the Igbo leaders like this? This is a country where the northern terror groups are being granted amnesty. These are people who have done all kind of havoc to this country. This northern group is not talking about all that. They are calling Peter Obi's name, saying if Peter Obi and other Igbo leaders are pleading for Nnamdi Kanu to be released, then they should equally be seen to be terrorists. Nigerians, how did we get here? Anyway, let me allow you to take a look at what this lawyer has got to say. Take a look.
The federal government, ought to have just pursued this matter straight, and, done with instead of this drama. The drama is really unnecessary. He was granted bail once, and then subsequently the army invaded his house and frustrated the bail. And so that, was a ground for even escaping. Eventually, when they rearrested him, brought him to court, I remember even those that took him on bail, they were excused because the bail was frustrated by the army invading his house. So all of this attitude will lay credence to the fact that the federal government has not been fair. The agitations of Nnamdi Kanu is as a result of the imbalance, inequality, and injustice in the land. And so once you address the balance, you address the inequality, you address, the hunger, unemployment, created by government ostentatious lifestyle and insensitivity on the part of government, agitations will naturally die down. So that is why I think government should not just be looking at the stick. They should also look at, take the blame in some cases, right. Look at what they have done to fan these embers, and by so doing, also listen to the plea and find a common ground to resolving all of these issues. Government should take the bigger blame.
The Federal High Court in Abuja on Monday indefinitely adjourned the terrorism trial of Nnamdi Kanu, leader of the banned indigenous people of Biafra, IPOB, after he challenged the presiding judge's impartiality. Justice Binta Nyako halted proceedings following Kanu's protest, marking the second time in under 5 months the separatist activist has rejected her oversight of the case.
Here's what you should know. Nnamdi Kanu was arrested in Kenya in June 2021 and extradited to Nigeria. He has been in the custody of the State Security Service since 2021 and is standing trial before the judge on charges of terrorism and treasonable felony arising from his separatist activities. IPOB, a banned separatist group led by Nnamdi Kanu, seeks an independent Biafra state in Nigeria's southeast and parts of the south. And also in September 2024, Kanu sought Justice Nyako's removal from his trial, claiming bias. She temporarily recused herself. Chief Judge of the High Court, John Soho, reversed the recusal, ordering Kanu to file a formal motion case reassigned to Nyako. However, during yesterday's proceedings, Kanu disrupted the process, roaring at Nyako for refusing to step down and criticizing judicial fairness. Joining us this morning to further discuss this is Liborous Oshoma, legal practitioner. Well, welcome to you, Liborous, and thanks for joining us on Breakfast Central this morning.
Yeah, good morning, and my pleasure always.
Let's start with this. Nnamdi Kanu questioned the jurisdiction of the Federal High Court in this case. Under Nigerian law, what are the key factors that determine whether a court has a proper jurisdiction to try a defendant, particularly in a case related to alleged terrorism and secession?
Yeah, we know, thank you once again, it is principles of elementary law long established in the case of Obeya Memorial that the federal government, the Federal High Court is empowered to try, matters bordering that has to do with, federal government agencies, especially, matters that have to do with offenses that are national, in outlook, for example, offenses of treasonable felony, offenses of terrorism, and all of that. And, matters against federal government and federal government agencies. So jurisdiction wears different toga. For example, if you discuss about issues of jurisdiction, service or processes, lack of service or processes can rob a court of jurisdiction on the ground that one of the twin pillars of natural justice have been violated, which means, auditory pattern, which is you must hear the other side. Yvonne would understand what I'm talking about, being a lawyer.
We have a lawyer in the studio.
Yes,
Olive is a lawyer.
Yvonne will understand. So, violating one of the twin pillars of natural justice, hearing the other side, and then so many other issues. If, for example, the matters brought before the court is one that the court lacks the power to look into. For example, if it's a state matter and you bring it before the Federal High Court, the Federal High Court, the defendant can, complain that that court lacks jurisdiction. But in this case, Kanu is not complaining about the jurisdiction of the Federal High Court. He's complaining, I think from what I heard, what I gathered, is complaining about the specific judge. And this is not the first complaint. If you also remember, I think about one or two other lawyers had recused themselves from Kanu's case. Ozekome was part of that team, and I also know that he withdrew from that case on activities such as this, where the defendant would want to take over his case by himself and not wanting, his lawyers to speak for and on his behalf. And then also, I would want to call on the federal government to expedite action on the matter. The matter had dragged on for too long. It's almost as if the government is not, ready. But the attitude of the defendant also, can be a clog in the wheel of the case. A situation where the defendant keep, objecting to judges, try him. That can also delay the matter. But all in all, I would, my admonition would be to both parties, to allow, the matter go on. If at the end of the day, the man is found innocent, he should be allowed to go. And then if he's found wanting, then he should face the music.
I mean, there's been a lot of
anyway.
There's been a lot of criticism as to the manner in which Nnamdi Kanu's case has been handled. And this criticism has been leveled not just against the government, but also the court. He's made very strong allegations against Justice Binta Nyako, which had led her to initially recuse herself. I would like us to speak about the authority the judge, first of all, after having recused herself, to be forced to continue with the matter. But let's take a look at this video. Nnamdi Kanu was speaking at the court, and then when we come back, I'll ask you the next question.
Corruption charges. They sent her to my case so they can release or smoothen the pathway for the husband and the son. They are facing, it doesn't matter if they off it. In a corrupt society, that's what happens. They are very, very corrupt. That is a breach of judicial oath. They have violated the judicial oath. They have shown bias according to Supreme Court. They are biased against me. Supreme Court said so. And that is why what is happening in the judgments and rulings concerning me has been happening. So, disobedience to Superior Court orders. Supreme Court said you are biased. You are against this man. You should not have revoked his bail. Nigeria went to Kenya and kidnapped him. These things are in the public domain. Why, therefore, are they insisting on trying me? A court order was entered. In that very court order, it was said very clearly and succinctly that she is no more. That she is no more going to try me. Why?
Right, that is a video of the IPOB leader Nnamdi Kanu speaking at the court. Mr. Liborous Oshoma, he's made very strong allegations as to the character and maybe competence in this matter of Justice Binta Nyako. He's alleged that the government, of course, is forcing this case upon her because they, in a way, have leverage. Of course, he didn't mention details, but we know that her husband, Murtala Nyako, and the son, Abdulaziz, had been tried by the EFCC for a case of fraud. Now, these allegations, as strong as they are, on who rests the burden to maybe conduct investigation as to whether there be conflict of interest in this case, and what should be the right steps? Does he have a right to raise this argument, and should maybe the body of benchers, or what body should be looking into the allegations that he's leveled against Justice Binta Nyako?
Yeah, first and foremost, in as far as the matter is concerned, these are two distinct and different matters. The allegations levied against her son and the husband are two different matters, and the appropriate agencies are looking into the matter, and if they are culpable, certainly they will go in for it. That does not rob Justice Binta, if you can hear me, it also does not rob Justice Binta Nyako of the powers to try the matter. Can you hear me?
Yes, we can hear you. Please go ahead. Please.
Yeah, so it also does not rob Justice Binta Nyako of the power to try the matter. So basically, these are two different matters. And then when issue of bias is raised, most cases, what the judges do, they send the file back to the admin judge or the chief judge, and then you make a formal application, and the chief judge will review your grounds. And then if truly there are any likelihood of bias, then the chief judge can assign a file back to another judge for trial de novo. But in this case, I do not see the allegations that a judge's husband or son is facing trial for corruption as a ground for being biased against a matter that is brought before another person by the federal government. If at all, even if that's the case, any judge could have done the bidding of the federal government if that's the case. Not necessarily, Justice Binta Nyako. So, but as the case as it is, the judge had sent the file back to has adjourned the matter. What do you call it now? A sine indefinitely, and that also does not help the case of the defendant Nnamdi Kanu in this instance. Also, he raised the allegation of a Supreme Court judgment or ruling. I would have expected that this would form the grounds for his final address in the matter, ordinarily, or file a preliminary objection, at the first instance. So all of this can be argued, and eventually this matter gets to Supreme Court, and the court will look at it holistically and rule on it. Otherwise, all of these interviews on TV and the rest will not form the records of the courts. So the best thing to do would be file application, state all of these issues in your application, or let it form the basis for your final address after examination in chief, cross-examination, and re-examination. And then it will form the record of the court that will, also enable the Supreme Court, the final court, to look at it, since he has also raised the question of a subsisting Supreme Court judgment.
Now, Mr. Oshoma, Nnamdi Kanu did talk about bias. He alleged bias. He also said a number of judges don't want to touch his case. That if that's the case, he should be moved to the southeast. What process? Is this something that is legally permissible? And what do you make of this? What's your thoughts on his suggestion that his case should be moved to the southeast?
The defendant, first and foremost, the Federal High Court, by myriad of authority, has been held to be just one court. And so the jurisdiction of the Federal High Court is, national. So, and Abuja being a central place, considering security implication also, the federal government, in its wisdom, decided to try the matter in Abuja. And so, I think also his attitude is what is discouraging a lot of judges from even touching the case. Even if the matter is moved to the southeast, what's the guarantee that considering the volatile nature and the insecurity in the southeast, that judges would, with this kind of attitude, will not, threaten judges to submission? No, it's not in the place of a defendant to elect and choose, which courts, without any, substantial reason. Like I said, the reason certainly would, be contained in a formal application, and the chief judge will look at them, and if the reasons are not weighty enough, the judge can always say, look, these are no reasons, because it is not every allegation of bias against a judge without merit, without meat, that the court will look into. The judge can say, well, you've levied allegation against me. I'm not even ready. I have so many other matters to handle. So I'll take the file back to the admin judge. But the admin judge can look at it and say, no, you continue handling the matter because there is no meat in these allegations. And I also do not think with this kind of attitude that the federal government will be ready to take the matter to the southeast, for trial, considering also the allegations that he's been levying against him. But and lastly, like I said, I would advise him and his lawyer to this attitude will not encourage, serious-minded lawyers, permit me to use that word, will not encourage some of his lawyers, will not encourage some of his lawyers to continue in the matter if he wants to do the prosecution or the defense by himself. Rather, he has employed lawyers to represent him. Let them represent him properly and then adequately. And most of these issues, put them, in the records of the court, because all of these ones now will not be in the record of the court. And it is that attitude that people are saying. Imagine telling a lawyer, shut up, don't talk when I'm talking. Some of these things, people will see them and will feel that, it's been, dramatic and will also not help his case.
All right. I mean, there are those who would argue that a part of the reaction will be based off the way and manner in which his matter has been handled over the years. Speaking as well about, his the way in which he initially was granted bail and the matter was sort of revoked and he had been held in detention for the longest time. We've seen a public outcry by Nigerians saying that he's been treated unfairly and unjustly. And whilst I know that the court is not a Father Christmas and it only grants, the prayers that have been brought before it based on the facts that are before it, is there sort of any weight to the emotions that have been expressed by a number of Nigerians? Because that's part of what we're discussing today, when we get to what Nigerians are saying later. If you see the reactions on X, majority of the reactions we have seen have been people advocating that he be given the same leniency that the quote-unquote terrorists have been given, and his matter be treated with that same care in which we've seen in the case of terrorists being forgiven and the likes. Is there sort of any merit to these standpoints?
Yeah, it is for me, they say let justice be done if even the heavens will fall, because the heavens will fall. But in doing justice is not a one-way traffic, it's a two-way traffic. Justice to the defendant and justice to the prosecution. The way government had gone about the matter, really, I would not, sit down here and say, yes, there's been, justice to him. The way government has handled the matter also had given credence to the fact that, government is unnecessarily sentimental and biased about prosecuting him. They are truly not ready, to prosecute him. It is almost as if, they are persecuting him. And it reminds me of the case of Al-Mustafa that dragged on for years, and eventually, he was released. And so that is why I think that all of this certainly would come to an end someday. I may be a political solution to the problem, because in a country where, like you have rightly pointed out, in a country where, people who are charged with terrorism are rehabilitated. I know people would want to say, okay, no, now he's a leader of a group. But it's his right, like you said, it's his right to agitate. And if federal government feels threatened, or they feel that, there are issues that borders on terrorism or treasonable felony, it is proper for them to table them, appropriately, and not in this hide and seek manner. Today you bring this charge, tomorrow you amend, he's granted bail, you revoke the bail, the court asks DSS to release him, and they still hold him in custody. It truly also means that the federal government is either not even interested in whatever the court will say, they are using the court to hold him, which is why I think that since the Supreme Court had made a pronouncement that they are biased against him, that's the best thing to do is to, if I were in his shoes, I would, because you have 3 levels here, I would forget about whatever will happen at the Court of First Instance and pursue my case diligently there, ensure that all the records are in all the processes and arguments are in the records of the court, and then subsequently appeal, knowing fully well that someday a final court will give a verdict, and they have given one before. And so all you just need to do is to ask the court, when the matter gets to that court, to revisit the issue. This issue of back and forth, at the end of the day, the judge now also had adjourned sine die. So for that period, he will remain in custody. Nothing is earned, nothing is gained. The federal government has not been fair, and also he's not helping his matter.
Now, considering Kanu was arrested in a very commando-like fashion in Kenya, reminiscent of the Umaru Dikko saga in the 1980s, does international law, including international principles of extradition and human rights law, have any bearing on the legitimacy of this case? Can Kanu's legal team leverage on international legal instruments to challenge this trial based on the way he was extradited from Kenya?
That's a diplomatic matter between the Kenyan government and the Nigerian government. I do not think that he would be, permit me to use the word, bundled out of Kenya without the connivance, active connivance and collaboration of the Kenyan government and immigration authority. So Nigeria is not a superpower to that extent that they will just muzzle out the Kenyan government, and just go uproot a citizen in Kenya. So that would be a diplomatic issue between them. I do not think that it is a ground that the lawyers can leverage on, because the offenses for which he's being tried were allegedly committed on the soil of Nigeria. And it is immaterial the way he is brought into Nigeria. It is the Kenyan authority that can complain that a citizen or
so regardless of how he found himself in Nigeria, it doesn't matter by any means necessary, as long as they brought him to Nigeria.
Regardless of how he finds himself in Nigeria, the fact remains that if the offense is committed here and is being tried here, it is the government of that country that can challenge, the way he's removed from their country, internationally. And not, I don't think it would be a defense to him, available to him, to complain that, the way I was brought here robs the court of jurisdiction. The question still remains, are these offenses, are these acts, offenses in Nigeria? So that's the issue that I think federal government should face. And really, like I said, the federal government, should show, what do you call it now, diligence in prosecuting this matter. They have not shown diligence. They have been dilly-dally. They have been back and forth. file application today, withdraw it tomorrow, amend charges today from treasonable felony to terrorism, and all of that. It's almost as if, you know what, let's use the courts to hold him down. So that's the area his defense should actually explore, and not the way and manner he was brought into Nigeria. If the Nnamdi case that you refer to, if they had succeeded in bringing Nnamdi from London to Nigeria, it would have been a different kettle of fish altogether. They would have tried him here.
All right, let's talk about, what legal concerns we might have as a result of how Nnamdi Kanu'S case has been handled. Yes, you've said that Nnamdi Kanu has particularly not helped his case with the manner in which he's gone about it with his lawyers, but you've also agreed that the federal government hasn't been utterly fair. They haven't acted fairly towards Nnamdi Kanu, especially as many would argue that the federal government has acted in a capacity that overrides the judgment of the court. Are there any worries and concerns as to what this might mean for other cases and what precedents this might be setting in Nigeria's legal landscape?
Yeah, it's set a very bad precedent. Also, it puts a big question mark in our ability to successfully, independently, and unbiased prosecute cases of this nature in an unbiased manner. That's the big question. And whatever whatever verdict the courts of first instance reach tomorrow, people are going to look at it from the prism of bias and persecution. So that's why I think the federal government, ought to have just pursued this matter straight, and done with, instead of this drama. The drama is really unnecessary. He was granted bail once, and then subsequently the army invaded his house and frustrated the bail. And so that, was a ground for even escaping. Eventually, when they arrested him, brought him to court, I remember even those that took him on bail, they were excused because the bail was frustrated by the army invading his house. Mm-hmm. So all of this attitude will lay credence to the fact that the federal government has not been fair in handling the matter. So I will encourage them, especially the Chief Justice of Nigeria, to ensure that, they look into the matter at the level of the NJC and give, further directive to the prosecutor. If the prosecution is not ready, then the court can strike out the matter. When they are ready, they can always, refile. And then for Nnamdi Kanu, I also think he should allow his lawyer, do more of the work and ensure that, at the end of the day, the records are straight. Because all of this, like I said, someday will come to an end.
Now let's look at the current situation, the latest, the legal implications of an indefinite adjournment. Justice Nyako adjourned the case indefinitely, despite the prosecution's readiness to proceed. What does an indefinite adjournment mean in legal terms? And what are the potential implications for both prosecution and defense? When are they going to come back together? Does it mean Nnamdi Kanu is going to remain in detention indefinitely? Who needs to step up and, bring all parties together so they can expedite this case?
That's why I said Nnamdi Kanu also is not helping his case. A man wants to keep you in custody in perpetuity. You are fanning the embers of that request by all of those asking the court. So what the court has simply done is there's a request, verbal request from the defendant for the court to, recuse herself from the matter. And so now the court simply decided to so do. And with this adjournment sine die, you don't even know when the matter will come up. Maybe the judge might just minute the file again back to the Chief Judge of the Federal High Court. And while all of this is taking place, the young man will remain in custody. And, so...
but this could be interpreted as a delay tactic on the federal government's side.
No, it wasn't a request from the federal government. This was a request from the defendant himself. He does not want the judge. What do you want the judge to do when there is a formal request, whether formally or informally, and he says, look, I will not submit myself to your jurisdiction? Should the court insist on, going ahead with the matter?
But I think the argument for Nnamdi Kanu in this case is the fact that Justice Binta Nyako at the last session had recused herself.
So why is she coming back?
So now we're seeing that the Chief Judge of the Federal High Court...
It is not in Justice Binta Nyako's, what do you call it now? It's not in her place to say she will not try a matter. Matters are assigned by the admin judge or the Chief Judge. So if she recuse herself and she sends the file back to the Federal High Court, to the Chief Judge, and the Chief Judge looks at, because a formal application was requested by the Chief Judge from Nnamdi Kanu and his team. And that formal application, after the Chief Judge probably would have looked at it, and he found out that there is no merit in that application, he will send the file back to the judge to continue from where they stop. So it is not in Justice Binta Nyako's place to say, I will try it or I will not try. There is an admin judge that assigns matter. So if the file is reassigned to her, certainly she will continue with the matter. If the allegation that he raised, that the court feels that there are no merit in it. So it wasn't she who willingly or voluntarily, by practice of court, to say, I want to continue the matter. The matter was reassigned to her. That's probably why, she's taking up the matter again.
All right.
Thank you very much, Barrister Liborous Oshoma. I'll let your legal colleague take over.
I just wanted, a final question. And the final question would be that in the interest of peace, the government has argued, or there have been arguments that Nnamdi Kanu'S, the reason why they did override the judgment of the court at the time was that releasing him might, aid or incite the insecurity in the southeastern part of Nigeria. Well, he's been held down. Sorry?
It is not in their place to do that.
Yes.
If the court has made a pronouncement, you obey the pronouncement of the court. You don't go back and say that there are supervening circumstances. You first and foremost obey the judgment of the court, and then
you challenge that.
Bring superior facts.
Yes.
You can bring superior fact before the court, or you challenge that decision. But to on your own sit down and say you will not obey because of certain perception, for me it is it's not justice.
And thank you for pointing that out. So now that we are unfortunately where we are in the Nnamdi Kanu case, or with the Nnamdi Kanu case, I know that when it comes to law, a number of times they will try our best to explore alternative means of dispute resolution, so long as it doesn't have to lead to a dirty fight. Are there ways that the government can incorporate some sort of dispute resolution to hear not just the cry and the plea of Nnamdi Kanu, but also the supporters who are demanding his release? Bear in mind that he's been held in detention, and it hasn't reduced the spate of insecurity in the southeastern part of Nigeria. So in maybe 30 seconds, are there other measures
quickly,
that the government...
I will tell you that the agitations of Nnamdi Kanu is as a result of the imbalance, inequality, and injustice in the land. And so once you address the imbalance, you address the inequality, you address, the hunger, unemployment, created by government ostentatious lifestyle and insensitivity on the part of government, agitations will naturally die down. So that is why I think government should not just be looking at the stick. They should also look at, take the blame in some cases, look at what they have done to fan these embers, and by so doing, also listen to the plea and find a common ground to resolving all of these issues.
So guys, you have seen what is happening in this country. Honestly, things don't balance in this country. Things are not balanced. Things are not balanced in this country. I'm just wondering where these people got this kind of audacity. I'm wondering how this boldness came about to say that Igbo leaders who are asking for Nnamdi Kanu's release should be seen to be terrorists. Nigerians, naturally, I don't like talking about all this secession news, but I think it's getting to that point where I'm like, no, this is not going to continue. It's not going to, we can't keep quiet. No, we can no longer keep quiet and just watch the federal government mess up a tribe that has contributed significantly to the progress of this country. Tell me what Northern Nigeria has contributed to this country. We are putting a whole lot of money into budgeting for the military, budgeting for insecurity because of the North. No other region. And they have the audacity to call Igbo leaders terrorists because they are asking for Nnamdi Kanu's release. In short, if indeed we have leaders, I think they have to come out and speak. if the Igbos still have leaders, for this northern group to come out to say that any Igbo leader asking for Nnamdi Kanu'S release should be seen as a terrorist, they should come out to ask them to withdraw this kind of statement and issue an apology. Igbos, you people should stand up. Enough of this, taking a people for granted. These are people who are well learned, who are very successful, and they know to have the audacity to be talking to the Igbos like this. I don't think it worth it. I don't think they should. If anybody should even talk, it shouldn't be the North. Considering out of school children is loaded in that area. They don't care for their people. They don't care for their children. They have been in power the most. They can't do anything for their people. They can't. And they are making jest of the Igbos because Nnamdi Kanu is in jail. But all the people who have fought for Boko Haram, they are being released. They are being granted amnesty. They are being given taxpayers' money. And some of them go back to fight again for Shekarau. So guys, what is happening in this country? How did we get here? How did we get here? Nigerians, how did we get to where we are? It's unbelievable seeing what is happening in this country. It's really, really unbelievable. I don't think we are going to continue like this. If indeed they don't want the Igbos, please let them go. It's not by force. If the Tinubu's government does not want the Igbos to be part of the country, let the Igbos go. If they do not want the Igbos, let the Igbos go. That's even the essence of Nnamdi Kanu agitating. Say, allow the Igbos to go. Why are you keeping the Igbos? Allow them to go. We used to say one Nigeria, but I think people are just taking us for granted because we are canvassing for unity of this country. Together we stand, together we are better. But look, yesterday there was a session on the National Assembly where I think a bill was being, proposed, and it was discovered that the Southeast was sidelined on railroads and other kinds of roads that the Tinubu's government want to build. And one of the representatives, the lawmakers, stood up to ask why is the Southeast excluded in this national project? Why is the Southeast excluded? Buhari did his worst in excluding the Southeast in almost all his projects. He rather preferred to go to Niger Republic to build railway. Then we have Rotimi Amechi, who claims he's an Igbo man, as the minister of works or roads. He was there mapping out where and where to build railway and denied the Igbos that opportunity. Now the Tinubu's government has come again. The same thing is happening. And when the people agitate, you pick them up and lock them and accuse them of terrorism. This is wrong. Let's call a spade a spade. So guys, I don't know what you make of this video. Let me know your thoughts in the comment section below. Please don't forget to subscribe to the channel, turn on the notification bell. Please give this video a like so that YouTube can recommend it to others, and drop your thoughts in the comment section below. Thank you.